2016 after that scathing judgment by Judge Francis Legodi, who agreed with the General Counsel of the Bar that they were not fit and proper for their jobs. Well, we're joined now to discuss this by senior legal journalist with Tiso Black Star, Karyn Maughan, and Zola Majavu, the attorney for Nomgcobo Jiba. They're joining us in studio. Karyn, let me start with you in terms of just painting the picture of where all of this comes from. It all started with the decision to drop charges against Richard Mdluli, did it not?
Yes, there were a number of complaints that the GCB pursued before Judge Francis Legodi, but the pivotal one, which he found had a basis, was this issue of the handling of the case against Richard Mdluli. It wasn't just the decision, which was actually not made by Nomgcobo Jiba. It was made by one of her deputies, Mrwebi, who was also joined in this matter. But it was really the General Counsel of the Bar expressed a great deal of disquiet about the way in which Ms. Jiba allegedly handled the litigation challenges to that decision, and essentially found that she hadn't acted in a fit and proper manner. Now, what has happened today is that the appeal court has found that while there may have been a certain degree of incompetence in her behavior, and that would be a matter for further inquiry, it has found that the GCB has failed to prove that what she did amounted to misconduct, and it's failed to prove its case in that regard, and it's therefore overturned this decision by Legodi that she should be removed from the Bar of Advocates.
In fact, the majority judgment today at pains to point out that whether or not you agree with the actions that were taken, neither of the two stood to benefit personally from the decisions they were taking.
Absolutely, and I think that was a pivotal part of the court's ruling. But in contradiction to this, and I've never seen this before, it's truly an extraordinary ruling. We have two judges on this bench of 5 judges going in completely the opposite direction and basically saying that Nomgcobo Jiba has lied and is a dishonest person who should be struck from the role of advocates. It is truly an extraordinary ruling, and I think we will see repercussions for this in the days to come.
Yes, indeed. We'll unpack some of those details a little later on. Zola, let me bring you into this conversation. If we go back to what happened 2 years ago, this was around fitness to hold office, and there are a number of determinants in terms of what the court has to consider to make that decision. And of course, I would imagine one of the things that they need to deal with is whether or not the complaint, for example, that has been brought before the court will talk about conduct that's been established on a preponderance of probabilities, what is expected of such a person, and whether or not, of course, they must be removed or indeed suspended.
You're absolutely right. I think let me foreshadow my engagement with you by saying the following very quickly. One, I think I would like to commend my client, Advocate Jiba, for accepting our advice to maintain a dignified silence throughout this ordeal when all and sundry had a lot of bad things to say about her. Coming to the issue on hand, firstly, she is vindicated because at all material times she had maintained that there is nothing about her conduct personally that would warrant her removal from the role of advocates on the basis that she is not a fit and proper person. What are the determinants that tend to gravitate towards that finding? It's whether you lied, you are dishonest, you've got a propensity to lie, or to behave in a disgraceful manner. Typically, advocates and lawyers are removed from the role for having embezzled clients' funds or behaving in a manner that they stood to benefit personally in circumstances where they were not entitled to. In this instance, one, there was no finding by any court that she behaved in a manner that warranted her removal, other than the Legodi judgment. What had happened was there were 3 separate cases in which her conduct as an office bearer was criticized. In passing, judges will say you were dilatory in filing an affidavit on time. In another criticism, she was criticized for having failed to file a record in a review application. And on the facts, we were trying to explain in the lower court that that criticism was actually meant for the National Director, National Commissioner of Police. And in fact, the ACA found that on the facts, they clearly got it wrong. Now, initially, when an application was brought by the GCB to seek her striking off, it was based on 3 different judicial complaints. Judge Legodi, who wrote for that court, found that in the 2 instances, the criticism was without merit. And he found that he behaved in a manner that amounted to a misconduct in relation to the Richard Mdluli matter. This is the matter which was withdrawn by Advocate Mrwebi, but she was the acting national director at the time. That was the only basis on which she was struck off the roll. Now, on appeal, all 3 complaints were subjected to legal scrutiny, and the SCA decisively found that insofar as those 3 complaints were concerned, there was absolutely no form of misconduct. Now, if misconduct is not proven, you fail the jurisdictional requirement. It did not even need to go to the issue of sanction. That is why the SCA felt that the lower court misdirected itself and overturned the striking off. The striking off had serious consequences. It meant even if she were to leave the NPA, she could not ply her trade as a professional, as a lawyer. And we can imagine why we were determined to fight it all the way.
Right, of course, Karyn, as you pointed out, that's what the majority judgment says in this instance. But as you point out, the minority judgment of 2 judges disagrees almost entirely with what we heard. So that obviously opens up all sorts of possibilities. But let's go back to some of the history that's involved here. As you pointed out also, it wasn't just the Richard Mdluli matter. There were decisions around Boyson's, for example. What was the history, what was the background that got us here in the first place?
Essentially what this matter is 4 judgments. Those judgments relate to Advocate Jiba's conduct in the DA's attempt to review the decision not to prosecute Jacob Zuma, particularly in regard to the record issue and her handing or not handing over those so-called spy tapes, recordings and the transcripts, in which she received quite scathing comments from Judge Navsa, basically impugning her professionalism and her role within the NPA. There was the Boyson matter, where she was facing criminal charges at one point, which was subsequently withdrawn by now NPA head Sean Abrams, on the basis she was facing charges of perjury and I think it was fraud in relation to these averments that she had claimed that she had received certain sworn affidavits that justified her decision to charge Johan Boyson in connection with racketeering, when in fact those documents were in fact on the evidence of the court or the findings of the court, not necessarily before her, or what she claimed to have seen was not actually there. Then of course there was the Richard Mdluli matter, and then there was a subsequent appeal judgment which was also quite scathing of her in relation to those cases. So it was quite a large nexus of evidence, and what is fascinating is in the minority ruling, where these judges have now looked at all 3 of those issues, as has been pointed out, they have actually said that in all of those cases, beyond what Franz Legodi said, she was dishonest and she lied to the court.
I mean, there's a Breitenbach matter, for example, where they say that, at best you could say there was naivete on her part, but they raise serious questions around even her competence. It may not be that, as you are arguing, Zola Majavu, this is about their roles as advocates, but certainly what does all of this suggest then about their fitness to hold senior positions within the National Prosecuting Authority?
Well, what is a pivotal issue, and I'm sure Ms. Majavu will address this, is that the North Gauteng High Court is in fact, gave an order, judgment in December last year, basically after an application brought by Freedom Under Law, which essentially concerned the rationality of President Jacob Zuma, as he then was, decision not to bring disciplinary inquiries against Advocates Jiba and Lawrence Mrwebi in relation to these various court judgments against them, all of those court judgments. And the court essentially ordered the President Zuma at that stage to institute disciplinary inquiry, but the court said, pending the determination of this GCB matter, this matter needed to be put on ice. Now, there has been an appeal launched by Advocate Jiba and the NPA against that determination, in which Sean Abrams' decision not to pursue those charges, the criminal charges against Advocate Jiba, has also been reviewed and set aside. And they're now taking that on. And that case is going to have very massive repercussions for what you're just discussing earlier about this issue of whether or not these individuals will face inquiries and will, in a public spectrum, be able to answer to these allegations against him, which, as Mr. Majavu has pointed out, up until this point, Advocate Jiba has not had the opportunity to fully do. She has retained her silence to a large degree.
Now, you would, of course, have claimed or seen today as a vindication, as a victory, but is the journey necessarily over? Because, of course, because the court was so divided today, it's very likely that the GCB could take this all the way to the Constitutional Court, and given the fact that they were so divided, that's a possibility. What does that imply for the inquiry that President Ramaphosa now has to give effect?
Two things that I need to make. One, the journey is not over, but the victory today was about her being struck off the roll, because that would have deprived her of the capacity to practice as an advocate beyond the NPA. So it is not to be undermined. But secondly, what the president may or may not do is something that we must wait and see, and we'll respect that. The president is inclined to go the inquiry route. Our client will subject herself to that process because she's not above the law. But I think there is something that is sinister here. The FUL has been saying all manner of things about this particular outcome, and they were not a party to this matter. People are losing sight of that. The parties were my client and the GCB. And the GCB, in fairness to it, has not made any pronouncements. It is up to them to decide whether or not they accept today's SCA decision or not. If not, the logical step will be to go to the Concord, and they'll have to give notice. And in terms of that, when that happens, we will then respond accordingly, and the matter will be vindicated there.
So whilst they may obviously be able to practice it as advocates, but the question that still remains is the fitness to hold positions within the NPA. Can you deal with that?
That's exactly the point. The court, the SCA has found that the basis on which it was argued and found that they must be struck off the roll has now been found to be lacking in substance. That is why they are reinstated. Whether or not they are fit to practice as officials of the NPA is something that is to be determined in an appropriate inquiry, and the outcome thereof may then have its own consequences. Hang on. The point here is an impression seems to be created that she is stopped from going to work. She was not suspended. She, on her own accord, asked to be placed on special leave, which her employer acceded to. Park that thought and imagine. Sean Abraham says the current NDPP, his own appointment was earlier set aside on the basis of irrationality and legality, right? He then took that decision on appeal. That is why he is currently occupying that position. My client's stance was simply different on our advice, which advice she accepted. So legally, there would have been nothing wrong stopping her from going to work. What you should be concerned about is what the FUL obtained was an order in December 2017 under the hand of Judge Motley, who said, amongst others, one, the decision to have charges against her pertaining to perjury withdrawn was set aside. So it means it remains open to the NPA to reinstitute those charges. I represented in that matter. If the NPA were to go that route, she will subject herself to that due process, and I'll defend her again. And what the outcome thereof would be is another matter. But the essence of those perjury charges related to how she handled the Johan Boysen matter, which even as early as the Judge Legodi decision, Judge Legodi found that there was no merit in that complaint. In spite of us going on appeal, we went on appeal against the complaint in relation to Mdluli. The SCA has found that in all of those three, no misconduct has been established. Now, it will be very interesting to see on what basis, if and when the NPA decides to reinstate those charges.
So, in short, does she, can she go back to work tomorrow? How does that? What happens now in terms of what that, how that must unfold?
Logically, the reason why she's not at work today is because she asked to be placed on special leave, pending the outcome of the SCA. We have now authored a letter. Whether or not it has reached the NPA, I'm not sure. But in the letter, we simply say the reasons that animated my request to be placed on special leave has now come and gone. I am tendering my services to say I'm available. It now becomes a matter between the employer and the employee to see how they work out those logistics. And it cannot be fair for me to comment in the public space about what it is that Sean Abrahams may decide on the matter. It will be discourteous. But that is how we are expecting the matter to pan out. It may well be that an attitude may be, let us await this outstanding FUL matter that is scheduled to be argued in August. Yeah. And if that were to be the case, we'll go back to court in August and argue and let the court decide. But for now, legally, there will be no impediment. But out of respect for due process, we may adopt a safe approach. But it is up to the employer to decide how they want to handle this matter.
And I suppose your last word then on this, Karyn, you've been covering these matters for a number of years now. What happens, where does this leave organizations like Freedom Under Law, who've been quite vocal even when, Nomgcobo Jiba just showed up at the NPA? They've had strong objections to that. How do you see all of this playing itself out going forward?
I don't think we can underestimate how pivotal this appeal with relation to this full judgment will be in August. I mean, it's really going to now kick this ball that was in the former President Zuma's court for so long, in which he was criticized for apparently failing to take concrete action given these judgments, firmly into the President Ramaphosa's court. He will then have to make a determination on, if this ruling stands, if it is not successfully appealed, which it may be, does he then act on that order, institute this inquiry and ventilate these matters for once and for all in the public domain, so that South Africans can be satisfied that either Nomgcobo Jiba has been falsely maligned for all these years, as her lawyer has suggested is supported in this judgment, or she has a case to answer. But either way, it's an open process, and it can leave the public with a sense that justice is seen to be done.
All right, we'll have to leave our discussion there. It's been a fascinating one, and as you say, the game is not over. Perhaps we'll call it half-time at this stage. We'll leave it there. Stay with us. We've got more news and analysis for you after this quick break.